perhaps in PDF, but somehow they were being forwarded electronically. And Mr. Kent made a request to the Office of Energy Resources. He wanted access to the applications, and he wanted them emailed to him. He didn't want hard copies. The Office of Energy Resources made clear that he could have access to the applications, but he had to. But they were going to provide him hard copies. He wanted electronic records. We found that, under this provision, the Office of Energy Resources had the ability to provide those documents electronically. They could have just emailed them, and not doing so violated this provision. Also on page 12, the bottom, and this is one of the cases where obviously we don't like to rewrite law or change law, but we've actually in the bound book edited this law a little bit. You see the strike-throughs on the actual bound book, and on the PowerPoint it's actually highlighted. Hopefully in the other rooms they can see that to solicit for commercial purposes has been highlighted. We've talked about this in some prior open government summits, but we just wanted to reemphasize, and it kind of makes sense to do the strike-through. This provision, or at least the highlighted part or the struck-through part, has been declared unconstitutional. So if you look at the general laws, you will see it as is, but it is unconstitutional. The highlighted provisions, we have highlighted them. They are unenforceable. The rest of the provision does stand. I've seen some situations where public bodies will deny records because, in public body's opinion, the person requesting them is looking to obtain a commercial advantage over that party, and doing so allegedly implicates this provision. This provision doesn't provide, even assuming the constitutionality of the original, of the rest of the provision, and the court didn't actually get into that, but assuming that, this provision doesn't provide a reason to deny access to records. It really is more focused on the person or the use of the person obtaining those records. So I would avoid citing this to deny records.
What is public? At this point, we're going to move from what I refer to as the black and white portions of the Public Records Act to the very gray area. Even for us at our office, we usually have to rely upon case law and our findings to try to establish what it is. Sometimes when we get calls on the phone, we get the sense that people think we must have some sort of checklist we go through, which we automatically tell you if the document is public or not. But we have to go through the same analysis as the rest of you. And although we're not going to be able to go through it in great depth, we're hoping right now that we can give you enough information to start you on the path to try to make some of these determinations on your own. A good way to try to understand the basis behind the determination of if the document is public or not is to look at the purpose, which you can actually find on the top of page 9. But I'm actually going to read to you the purpose that the Supreme Court of the United States said in its entitled Department of Justice versus Reporters Committee. Although the Freedom of Information Act is the federal law and Rhode Island's law is obviously the state law, the Public Records Act of Rhode Island is based upon FOIA, so it's appropriate for us to look at this case law. And actually, as a side note, we get a lot of requests from our office that are addressed to the Freedom of Information requests, and our policy in our office is to just treat those as if they are public records requests. But the Supreme Court said that the FOIA's central purpose is to ensure that the government's activities be open to the sharp eye of public scrutiny, not that information about private citizens that happen to be in the warehouse of the government be so disclosed. Thus, it should come as no surprise that in none of our cases construing the FOIA have we found it appropriate to order a government agency to honor a FOIA request for information about a particular private citizen. So we should keep that in mind as we go through our determination as to whether or not we think that something is public or exempt. As we go about our determination, it's really a two-step process. The first thing that you should do is go through the 25 exceptions that we will talk about, some of them in more depth in just a moment. If one of the 25 exemptions apply, then this document is not public. However, with one notable exception we will talk about later, a public body should feel free to disseminate this information if it so wishes. Once it has been determined that a document does not fall within these 25 categories, the public body should do the balancing test, which basically reflects the purpose that we just spoke. The balancing test is, does the individual's privacy interest outweigh the public's interest in disclosure?
Laura just mentioned that there are 25 exceptions. They're on page 9 to 11 of the bound book. We're not going to go through all of them, but we are going to go through some of them. And the one that we're going to start with is the first exception. It's the exception that really seems to come into play the most often. Records that are identifiable to an individual applicant for benefits, client, patient, student, or employee. We've seen this interpreted a little bit more broadly by the Supreme Court. We've seen in some of the past slides, we studied the DARE cases, direct action for rights and equality. Those were cases where the organization, DARE, had made a request to the Providence Police Department over like a 7-year period for complaints, civilian complaints that had been made against law enforcement officers. And DARE went to the Supreme Court twice, but through both of those cases, the Supreme Court made clear that under this provision, the names of those officers could be redacted, but because, what we talked about earlier, the reasonable segregable portions could be provided, the rest of the documents were public. The court also made clear that not only were the names of the employee/officers redacted pursuant to this provision, but the names of the citizens that had filed the complaints could also be redacted. So the court expanded it a little bit, or looked at it a little bit broader. We see some cases where actually in the last year it's been applied more broadly than it should be applied. One of the cases is a case called DeMonica versus Cumberland School Department. This was a case where Mr. DeMonica had made a request for absentee statistics for certain teachers or for categories of teachers. He made clear in his request that he was not looking for the names of teachers. He wanted to know how many high school teachers, what percentage, their rate of absenteeism was. For whatever reason, the Cumberland School Department denied it under the first provision here, under A1, because it was identifiable to an individual employee, even though Mr. DeMonica had specifically requested that he didn't want the names of the teachers that were affected. We found that that situation violated the Act, and Mr. DeMonica was entitled to that information. Another case is Romano versus Town of Exeter. This is a case where a timesheet was requested for the tax assessor. We've had a couple cases like that in the last year. Time cards or some sort of information similar was requested. In the Town of Exeter case, we found that was exempt. It was a request for information related to a specific employee, the tax assessor. The one type of situation that I would kind of jump from at this point to give you some thought, the Town of Exeter case was a case where a request was made for the time card or some records related to a specific employee, one employee, the tax assessor. Query whether, if the request had been framed differently, and this may have not been useful to the person who was requesting the records, but query whether the request had basically said time cards of all people from town hall or all people of this department. In that type of situation, it seems like we fall more in the DARE type of cases where you're requesting multiple records regarding identifiable individuals, and the names could be redacted out, and then that information could be provided. When you're requesting information, when the public's requesting information related to one particular individual, that may be more the situation where the entire record is exempt. There are actually Supreme Court cases. Brady, Kentucky Teachers Alliance versus Brady is one of those cases, and another one that we'll talk about later is Robinson versus Malinoff. Notwithstanding what I just said, that all records that are identifiable to an individual employee are exempt, towards the bottom of that provision, which is on page 9 of your book, there's a clause, the last clause, which says that with respect to employees, the following information is public. So to the extent that records fall within these categories, they are deemed public and have to be provided, even if they're identifiable to an employee. One of the exceptions, the Attorney General made reference to the law enforcement personnel that are in the office, is an exception for law enforcement records, but only if disclosure could, and it has to fall within one of the 6 categories. Reasonably be expected to interfere with investigations of criminal activity or enforcement, deprive a person of a right to a fair trial, reasonably be expected to constitute an unwarranted invasion of personal privacy. We'll talk about that in a second. Disclose a confidential source, techniques, or endanger the life of the person. Towards the end of that provision, and I think it's on page 10 of your bound book, you'll also see that records relating to the direction and management of a law enforcement agency and records or reports reflecting the initial arrest of an adult are public records.